All right, we had two new documents filed today, document 206 and 207. This one's 19 pages long, the other one's 49. But I'll get into this. Defendant Netflix Incorporated motion to compel production of documents responsive to subpoena to Michael Griesbach. Defendant Netflix respectfully moves this court, pursuant to Federal Rules of Civil Procedure 26 and 45, for order directing Mr. Griesbach produce records responsive to the third-party subpoena. Introduction. Today, Mr. Griesbach is one of three attorneys appearing as a counsel of record for plaintiff Andrew Colborn, but long before he joined the legal team, he served as assistant district attorney in Manitowoc County and authored 3 books about the underlying events here. Through that work, Mr. Griesbach built a significant collection of documents relevant to issue in this action. The documents include, among other things, evidence related to Stephen Avery's exoneration, civil case against the county, and subsequent conviction for murder, documents related to Mr. Griesbach's appearance in Making a Murder, and documents revealing the public's views towards Avery saga and the players involved in it, including Mr. Colborn, and how those views and the players' reputations were impacted, if at all, by the documentary. Netflix seeks those documents through a subpoena. Notably, in his objections to the subpoena, Mr. Griesbach did not claim that any of the information requested is privileged, nor could he, as Netflix explicitly tailored the subpoena to avoid discovery of attorney-client privilege information, rather to justify his refusal to produce any responsive records. Mr. Griesbach relied on the sort of wrote boilerplate objections that the Seventh Circuit Court of Appeals routinely rejects, including the information is otherwise available, not relevant, and other broad and unduly burdensome. Subpoena, however, seeks information well within the scope of discovery contemplated by the Federal Rules of Civil Procedure 26 and 45. Mr. Griesbach bears a burden to justify his refusal to comply with it for the reasons stated herein, and cannot satisfy the burden. Mr. Griesbach's objections should be rejected, and he should be compelled to comply with the subpoena. Background facts. Today, Mr. Griesbach is part of the team of 3 lawyers from the 3 different law firms representing Mr. Colborn in his action. But for more than 30 years, Mr. Griesbach was an assistant district attorney for Manitowoc County, Wisconsin, in his role as a prosecutor for Manitowoc County. Mr. Griesbach played an integral role in the 2003 exoneration of Mr. Avery for the rape of Penny Bernstein, and later he was involved in decisions made during the early stages of the investigation into the death of Teresa Halbach, including drafting initial search warrants for the Avery salvage yard. Beyond that, as his own representation, Mr. Griesbach became obsessed with the Avery case in 2003, more than 12 years before Making a Murder premiered, and more than 15 years before Mr. Colborn retained Mr. Griesbach as his counsel. He is the author of 3 books about Mr. Avery and Making a Murderer, including A Reasonable Inferences, The True Story of a Wrongful Conviction, and Its Astonishing Aftermath, 2010, The Innocent Killer, A True Story of a Wrongful Conviction, and Its Astonishing Aftermath, 2014, and Indefensible, The Missing Truth About Stephen Avery, Teresa Halbach, and Making a Murder, in 2016. The last of which was published more than 2 years before he began representing Mr. Colborn. He has spoken out extensively on radio, television, and print interviews about how Stephen Avery was, to use a colloquial term, screwed over by the former sheriff and DA. And he had given numerous media interviews regarding Making a Murderer. In fact, he was even interviewed by Netflix co-defendants Laura Riccardi and Maura Demos, the producer-defendants, and appeared in episode 1 of the series. In short, Mr. Griesbach is in possession of documents and communications of great relevance to Netflix defense. Netflix therefore served on Mr. Griesbach a third-party subpoena pursuant to federal rules on February 10, 2022. seeking discovery of documents and communications related in general to the research, drafting, and fact-checking of his books, to his communications regarding Making a Murderer, Netflix, and producer defendants, and to his work while assisting District Attorney on the pending Bernstein and Teresa Halbach cases. See Example 1. On February 24, 2022, Mr. Griesbach served objections to the subpoena and refused to produce even a single responsive document. Example 2. On March 8th, Netflix provided deficiency letter to Mr. Griesbach, which included a request to meet and confer regarding the subpoena. The meeting between counsel occurred on March 11th, and is confirmed in emails memorializing the discussion. Counsel for Mr. Griesbach made clear during the meet and confer that his client did not plan to produce any documents responsive to the subpoena. Accordingly, Netflix now respectfully requests that the court order Mr. Griesbach produce any documents responsive to the subpoena. Argument. Mr. Griesbach is far from a stranger to the case. Unlike more typical third party, he is fully aware of the claims and defenses at issue. Indeed, the state court complaint that commenced this action bears his signature and his signature alone. Presumably, Mr. Griesbach should have no trouble locating documents responsive to the subpoena or understanding their materiality. His vague claims regarding relevance, burden, and overbreadth thus fall flat. Indeed, his status as counsel of the record of the case reduces the burden he might otherwise face, and, explained in the further detail of Section 3 infra, the status in no way excuses him for obligations he faces as a fact witness. Meanwhile, Netflix subpoena to Mr. Griesbach seeks discovery of non-privileged information that only relevant but central to his defenses in the action that is unavailable from other sources. Thus, for all the reasons discussed herein, the court should compel Mr. Griesbach's compliance with the subpoena. The federal rules of civil procedure favor broad discovery. Mr. Griesbach objected to the subpoena on the grounds that the evidence is not relevant pursuant to the federal 401 and that information and material that could never be admitted into evidence. However, the federal rules of civil procedure are very clear that the discovery is to be broad and liberal. The text rule of 26 enshrines the presumption of favor of discovery. Parties may obtain discovery regarding any non-privileged matter that is relevant to the party's claim of defense proportional to the needs of the case. And as Rule 26 makes explicit, scope of discovery need to be admissible in evidence to be discoverable. What is relevant includes more than what is admissible. Relevant is discovery and broader than the relevance in trial. During discovery, a broad range of potentially unuseful information should be allowed when it pertains to the issues raised by the parties' claims. The scope of the information that can be sought through a third-party subpoena is as broad as what is otherwise permitted under Rule 26. And the general creation for the judicial review of subpoenas, including subpoenas directed at third parties, is whether, I lost my place, the subpoena is responsible in the circumstances. Before restricting discovery, the court should consider the totality of the circumstances, weighing the value of material sought against the burden of providing it, and taking into account society's interest in furthering the truth-seeking function, in particular the case before the court. Factors courts must consider presented within the motion compel include timeless, good cause, utility, and materiality. Discovery sought by Netflix neither overly broad nor unduly burdensome than Mr. Griesbach has filed to demonstrate otherwise. Mr. Griesbach argues in a single conclusory sentence that Netflix discovery requests are overbroad and unduly burdensome. But his objections fail to address a single one of Netflix requests individually or explain why any particular request is improper. Such wrote facially deficient objections, tantamount that objections at all are ineffectual, and every court in the country has held. Burden requests upon the objecting party to show why a particular discovery request is improper. This is true even on motions compelled directed by third parties. Thus, Mr. Griesbach must state with specificity of the grounds of rejecting the request, including reasons. Stating the party resisting discovery must adequately demonstrate the nature, extent of claimed burden by making a specific showing as to how disclosure of the requested documents, information would be particularly burdensome. This showing typically requires affidavits or other affirmative evidence supporting a party's assertions of burden. Objections to recite boilerplate the language without explanation of how to apply the specific discovery request do not meet the burden and are routinely overruled in the Seventh Circuit Court. There's a footnote here. As the court explained in Ditchman, there's nothing unusual about the broad subpoena. A subpoena is normally just a means of opening discussion between discoverer and discoveree. The discoverer asks for too much because he is not, until he is told, aware of the discoverer's problems. When a court is confronted with a motion to quash such a subpoena, its duty is not to deny the discovery, but to reduce the demand of what reasonable considering discovery's needs and discovery's problems. Here, Mr. Griesbach made no showing, specific or otherwise, as to how the subpoena would burden him at all, much less burden him unduly. Recognizing the question is not whether a subpoena poses a burden. All subpoenas pose some burden, but whether the burden exceeds the benefit of production of the material sought by it. As Netflix demonstrates below, its subpoena is neither overly broad or unduly burdensome because it targets the discovery of specific, non-public information that is uniquely in Mr. Griesbach's possession and is relevant to Netflix's defense. Netflix seeks non-public information uniquely possessed by Mr. Griesbach. Mr. Griesbach claims the requests seek evidence that is otherwise available, but he fails to identify what the specificity of which requests seek only publicly available records. Mr. Griesbach's failure is unsurprising given the subpoena seeks document uniquely Mr. Griesbach's custody and control. For example, document request 2 seeks all documents and communications which consulted, relied upon, sent, received, or used in writing the books. In his book, Indefensible, Mr. Griesbach references at least 2 non-public sources who provided information for the book. First, he describes how a detail-oriented, Avery-obsessed Redditor friend of mine investigated various phone calls Stephen Avery placed on the day Teresa Halbach was murdered. Indefensible 178. Second, he explains how spoke to Colborn about making a murder and how he felt about it. Colborn responded that he didn't watch it, but he had heard about it. He also claims that he only read the transcripts for the trial and never seen the documentary. And documents reflecting the information provided by these friends are responsive to requests of 2 and not otherwise available from public sources. Documents request 7-6 all documents and communications regarding or related to making a murder. Clearly, to the extent Mr. Griesbach sent to receive emails using a private email address, such as emails are not publicly available records and are not readily available to Netflix through another source, and documents produced to date make clear that Mr. Griesbach did communicate about these series using a private email account sent from michaelgriesbach@gmail.com with the subject line Sky's Interview, Read Netflix Documentary, Save at Home. Although this particular document was discovered through a subpoena to the Moanatoa County Sheriff's Department, that is only because Mr. Griesbach forwarded the email to an employee of the Sheriff's Department. Unless Mr. Griesbach forwarded every personal email to the employee of the Sheriff's Department, he is certainly in possession of other responsive, non-public information. So, with document request 11, which seeks correspondence between, among, and involving Ken Kratz regarding Teresa Halbach or Stephen Avery. According to a separate document obtained by Netflix in November 2005, Mr. Griesbach had a private meeting with Ken Kratz, Mark Rohr, and Detective Mark Wiegert, during which the decision was made to apply for a search warrant for this Avery salvage yard. According to this record, the meeting attendees also decided that the Calumet County Sheriff's Department would lead the investigation due to maybe a conflict of interest. Now, if you read in the KSO report or notes we have, it's Greg Shetter that mentions to Jerry Pagel that they currently have a lawsuit with Stephen Avery, and Jerry Pagel is the one that assigned Mark Wiegert, the lead investigator, along with Tom Fassbender. Now, where was I? Okay. According to this record, the meeting attendees also decided the Calumet County Sheriff's Department would lead to investigate due to maybe a conflict of interest. Mr. Griesbach recounts some of the details in the Indefensible when he explains that both he and Rohr felt that with Avery's wrongful conviction lawsuit still pending, with still 2 depositions yet to take place, being Dennis Vogel and Tom Kasurek, 2 days after he is arrested, which never happens, felt that Avery's wrongful conviction lawsuit pending, that there be conflict of interest if Manitowoc County continues to be involved. Yeah, but we all know that's a crock of lie, because they still investigated the whole time, and they don't ever file reports. It's thus clear that Mr. Griesbach has non-public information that is relevant to this case. What's more, Mr. Griesbach's assertion that Netflix seeks documents that are otherwise publicly available and directly contradicted by the separate objection that requested information protected because of the property. Okay, let me stop here. During this whole search warrant fiasco, when Michael Griesbach gets back to the command post, you can hear in the audio Mark Wiegert telling them to snatch the negatives for God only knows what photos, and he accidentally left part of the search warrants at the command post. It's all in the audio if you actually listen to it. The information Netflix seeks to relevant to defense of the action. As above noted, the federal rules construe relevancy and broadly that the relevant information need to not itself directly bear an issue to the case, but merely lead to other matters that could bear an issue to the case. Information subpoenaed, not relevant, is not enough to establish undue burden or show some other exceptional circumstance that would justify prohibiting the discovery altogether. Netflix subpoena to Mr. Griesbach easily clears the low bar. One obvious example illustrating the relevance of the requested documents related to Mr. Colborn's allegation the defendants led viewers to falsely conclude that the plaintiffs learned of the 1985 Avery's wrongful conviction for the rape of Penny Bernstein approximately 8 years before he was released, but covered it up. Mr. Colborn legends various specific facts with respect to the phone call he received regarding the identity of the actual perpetrator, and he contends that the defendants, Riccardi and Demos, strategically spliced and omitted portions of the plaintiff's trial testimony to distort the facts and nature of the 1994 or 1995 telephone call. Specifically, he alleges that he does not believe that the caller mentioned the name of the man identified by the caller perpetrator. I can't wait till this goes to trial, because when they ask him, why did you file a report of this phone call the day after Stephen Avery's released? Why did you wait 8 years? Why didn't you file the report right after you got the call? Every officer has a little notebook. They write their notes in. Then they're supposed to file a report. But this is Manitowoc we're talking about. In order to a statement to be defamatory, it must be materially false. Netflix is therefore entitled to defend itself by arguing that the underlying statements in American Murder were substantially true. And X and the falsehood. Also, discussing doctrine of substantial truth. Blah, blah, blah. Based on various public statements by Mr. Griesbach, Netflix reasonably believes that he possesses information relevant to his defense, and I do too. For example, during Mr. Griesbach's time as Assistant District Attorney, he was personally involved in Manitowoc County's investigation of and response to Stephen Avery's 2003 exoneration in the rape case that wrongfully sent him to prison for 18 years. A longtime Assistant District Attorney, Griesbach was then District Attorney Mark Rohr when the state crime lab called to notify him that the DNA testing ruled out Avery as the culprit in the 1985 rape and attempted murder of Penny Bernstein. Soon thereafter, Griesbach discovered that Manitowoc County prosecutors and law enforcement quite likely knew or suspected that Avery was innocent and that the man that the DNA test implicated, Greggy Allen, was the real rapist. Indeed, before Teresa Halbach's disappearance, Griesbach was deposed in Avery's wrongful conviction case, and his testimony suggested that Mr. Colborn himself either downplayed or misrepresented his role in bringing the call to the attention of his superiors in the sheriff's office. For example, Mr. Griesbach testified that he was aware in 2003 that other law enforcement officials said that Colborn especially told them that a detective from Brown County, specifically, he testified in 2003, he had discussed that DA Mark Rohr, a fellow prosecutor's memorandum, which reported that Colborn told former Sheriff's Department colleague not only that the caller was from Brown County, but that he especially identified both Allen as the perpetrator and Avery as the wrongfully accused. In addition, Mr. Griesbach testified equally that Colborn had confirmed to the DA's office that upon learning of the call, then Sheriff Kasurik had assured Colborn that we've got the right guy and that he should not concern himself. That sounds about right. Mr. Griesbach's books similarly call into question Mr. Colborn's inconsistent accounts regarding both whether the caller mentioned any names and the response to the call by his superiors in the sheriff's office. In his 2014 book, Mr. Griesbach, Mr. Colborn's Revelations in the Bombshell, a detective from Green Bay called Manitowoc County Jail to report that an inmate in the jail was claiming that he had raped a woman jogging on the beach in Manitowoc County 10 years earlier. The inmate claimed that someone else had been convicted of the assault and was presently serving time in prison for a crime he did not commit. The former Sheriff Department Chief Investigator Eugene Couchet told the ADA, Assistant District Attorney, that Andrew Colborn was corrections officer who spoke with the Green Bay detective, and the Colborn got word of it to the sheriff. Now, I'm going to stop right here because just a little side note. The whole time, Andrew Colborn is applying to be a sheriff officer, working in the jail. Every time he applies to become a sheriff, he's denied. And then, out the blue, he becomes a sheriff. And it's right around the time after this phone call has happened. According to Couchet, the sheriff told Colborn and a detective to stay out of it. They already had the right guy. Andrew Colborn doesn't recall if the Green Bay detective mentioned the confessing inmate's name, but Gregory Allen was in Brown County Jail at the time. Mr. Griesbach states equivocally that his book, the Colborn's 2003 report regarding the telephone call, was hidden in the sheriff's safe, not delivered promptly to the Attorney General. And Mr. Colborn contends in this action, the evidence related to this phone call is not only evidence relevant to the case that Mr. Griesbach possesses. Another example, In Second Amendment complaint, Mr. Colborn alleges defendants in concert heavily edited portions of the plaintiff's trial testimony in order to manipulate the viewers and to falsely conclude that he and other officers planted a L-box SUV at the salvage yard. Mr. Colborn then alleges that the defendants, jointly and severally, with actual malice, led viewers to incassably but false conclusion that plaintiff and the Manitowoc Sheriff's Office Lieutenant James Link planted the ignition key for a Hallbox SUV in Avery's bedroom. Again, Netflix is entitled to conduct discovery aimed at establishing the truth of what Making a Murderer says about Mr. Avery used the discovery of Mrs. Hallbox's car key to buttress his frame-up defense. Mr. Griesbach's own books make clear in his possession of the evidence relevant to the endeavor. On page 221 of The Innocent Killer, Mr. Griesbach details that after Teresa Hallbox's RAV4 were discovered at the Avery salvage yard, he helped draft the initial search warrant for the Avery property. The searches by Calumet County officers alone yielding nothing. Mr. Griesbach wrote, but a few days later, two Manitowoc Sheriff's Department detectives James Link and Sergeant Angie Colborn searched Mr. Avery's bedroom again when the key to the RAV4 were discovered on the floor behind the bookcase. This was the same time that Colborn and Link were being deposed in Mr. Avery's civil suit against the county. Mr. Griesbach himself wrote, the coincidence of the timing of their depositions and their finding Teresa's car keys in the Avery's bedroom was awfully strange. The participating cause of that search, however, was the search warrant Mr. Griesbach personally helped draft. Thus, the documents and communications consulted in preparation of the initial search warrant for the Avery property and clearly relevant and discoverable. Yet, as yet another example, Mr. Colborn alleges that Making a Murder and not Mr. Avery's trial itself or the news reports published at the time of trial harmed his reputation, even destroying his decades-long marriage. Just as entitled to engage in discovery of the element of Mr. Colborn's defamation claim related to materially falsity. Netflix is entitled to engage in discovery of Mr. Colborn's claims for damages, and Mr. Griesbach has personal knowledge and, in all likelihood, documentary evidence on this topic, which he details in his books. As an example, he writes about the considerable irrational anger that was directed at anyone associated with Avery's exoneration. Once Mr. Avery was subsequently arrested for the murder of Teresa Hallbox, as well as the near even divided public opinion on Avery's guilt for the new crime, The Innocent Killer, at 206 and 214 of the book, Griesbach writes that, for the most part, people's opinions didn't evolve. Some thought from the start that Avery was guilty as sin, and other opinions didn't change when Link and Colborn found the keys. Others, however, were convinced in conspiracy to convict Mr. Avery. Other passages in Mr. Griesbach's book similarly undercut key allegations in Mr. Colborn's Second Amendment complaint and are likely to lead to relevant evidence regarding community reactions to Making a Murder and the impact the documentary had, if any, on Mr. Colborn's reputation. For example, you guys enjoying this? In his 2014 book, Mr. Griesbach described a conversation with Link in which Mr. Link expressed anger that Avery's defense lawyers had accused him and Mr. Colborn of planting evidence. Mr. Griesbach wrote that charged with the crime has a constitutional right to defend himself, and the media has a right to cover the story completely. Mr. Griesbach wrote that the quirky circumstances around the investigation scared him, especially how Colborn and Link were the ones to find the key. Why does he write keys? There's only one key. At 236, and the prosecutor's attempts to soften the blow of the evidence rang hollow to many. He also noted that the Calumet County officer supervising their search of Avery trailer retreated from the statement. Lincoln Colborn could not have planted the key, admitting it was possible, but he also stated that aliens could have put it there. In his third book, which is focusing on critiquing Making a Murderer and rehabilitating his now client's reputation, Mr. Griesbach acknowledges that the law enforcement officers whose depositions experts were included in Making a Murderer looked more defensive than they have, and they have nothing to hide. When I later watched the complete video of the depositions and the officers who were most directly accused of wrongdoing, either in the first Avery case or the second, my concern that they had something to hide through statistically reduced was not completely elevated, and that was not simply a case of only selective editing to make him look bad. Also, third book, he writes about calls from viewers, Mr. Link and Mr. Colborn, received in the days after Making a Murder release, including on Christmas Day, when he had hoped to spend a peaceful day with his family, who still loved him. The book does not specify whether it was Mr. Link or Mr. Colborn who received the call, but in later, the statement obviously undermines Mr. Colborn's claim that Making a Murderer destroyed his marriage. Ultimately, knowledge of the evidence Mr. Griesbach acquired over the course of his decades-long obsession led him to email the producer and defendants just days after the series premiered on Netflix. I binged my way through all 10 episodes by Saturday afternoon and enjoyed it immensely. He wrote, I got a funny feeling, I don't know why, but I think Griesbach might have intentionally done this. Because there's no way, he's looking dumb right now in my eyes. He went on to say that shared most of his views he expressed in a recent newspaper interview, including especially Demos' statement that in the end, we are not trying to provide any answers, we don't have conclusion. We are really raising questions, and our goal is to promote a dialogue about these things. And Riccardi's assertion that one needs to be careful not to be certain about any of this. There's lots of room for ambiguity. Griesbach wrote in 2016 book, any issue complicated and controversial as this one, the truth is elusive in every case. Documents Netflix seeks Mr. Griesbach are clearly discoverable, irrelevant to Mr. Colborn's claims. The defendants, including Netflix, presented false statements of the fact that viewers this series defend Mr. Colborn, and that they did so with actual malice, either knowing the series was false or the reckless discarding the truth. Mr. Griesbach plainly stated in one of the 3 books on Stephen Avery, if only I had not been involved in the Avery story myself, perhaps then I could have simply enjoyed the craftsmanship of Making a Murder indefensibly. Protest as he might, he is not a witness in the matter, nor should be permitted to become one. The fact is that Mr. Griesbach is the person witness underlying events at issue, and he has been since long before the representation of Mr. Colborn in litigation. One need only review his books to see Mr. Griesbach possesses personal, relevant, and discoverable material related to the matters at the very heart of this action. Now, we have his books, so when we read his books, we can ask him, or they can ask him, where did you get this information to put in this book? And if he can't cough it up, we have a problem, because that means he probably destroyed it. The mere fact that Mr. Griesbach is a counsel of record in the matter does not preclude him from being ordered to comply with the subpoena. Indeed, it is clear that no special privilege and immunity shields the person from discovery simply because he or she is an attorney or even attorney for a party to the suit. Cannot claim harassment, undue burden with the opposing party seeks discovery from them. Little footnotes. Attorney who fact witnesses cannot claim harassment, undue burden with the opposing party seeks discovery from them. Granting motion to compel discovery directed to counsel for opposing party for information not related to counsel's representation in the matter. The mere fact that the individual employed by a party has a license to practice law does not institute him from discovery to create a massive hurdle that must be overcome. There is no general prohibition against obtaining the deposition of adverse counsel regarding relevant, non-privileged information. Rather, as the case of court made clerk, it's far better to follow the ordinary standards and procedures provided in the rules for resolving objections than to create a separate standard of attorneys. Importantly, Mr. Griesbach does not object to the subpoena on the basis that it seeks information protected by attorney-client privileges or attorney work product doctrine, or any other privilege for that matter. Netflix subpoena is explicitly tailored to avoid the possibility of seeking discovery of privileged information. Mr. Griesbach previously swore in his action that Mr. Colborn contacted him on October 2018 to ask if he would represent him concerning the subject matter of this action. Finally got an answer to one of the questions I always wanted to know. Did Griesbach come to him or did Colborn go to him? To ask if he would represent him concerning the matter of the action. Netflix subpoena specifically calls for the production of documents created before October 1st, 2018, the relevant to Netflix defense, but unrelated to Mr. Griesbach's representation of Mr. Colborn in this matter. Seek information concerning counsel's own actions, all of which were taken before this litigation commenced. This is a distinction worth making, where the attorney's conduct itself in the basis of a claim in defense, or there's attorney conduct occurred before litigation stated in anticipation litigation, the opposing party has the right to an attorney's testimony. In other words, the extent there exist privileged documents regarding the information sought by subpoena, Netflix officially exclude those documents from the scope of the subpoena. Mr. Griesbach's status as counsel for Mr. Colborn does not excuse him from complying with the subpoena. Conclusion. For the foregoing reason, Netflix respectfully requests that the court issue an order compelling Mr. Griesbach to comply with this subpoena. Now we just gotta hope that the courts do the right thing, Mr. Ludwig. There is a 49-page document that was filed right after this. I don't know, I might read that today. I might wait till tomorrow. I'm not sure yet. But, like, as I'm reading it, this is the first time I read this. I haven't even looked at the other document. So, your thoughts? I do realize this chat is delayed a bit. Y'all got any questions before I keep on keeping on? This is probably the best document I've read in this Colborn case. Besides the one where they tried using the state laws when they forgot that they're now in the federal courts. Knowing Wisconsin, they're probably going to deny it, or who knows? I don't know. The fact that this case has been jumbled around between 3 different judges now. I mean, first it was with Peppers, then it got moved to Ludwig, and then Ludwig passed it off to Riley to mediate, which was no use, and then it got thrown back to Judge Ludwig. So and then Colborn requested the judge, because he was part of Brendan's case and shit. All these appeals judges, they're all connected to Avery, some way, some form, some fashion. And it's not even just the judges, it's the state attorney general. It's political, 100%. I don't know how many times I have to say this. There's too many people involved. That's why they're fighting. As soon as Stephen Avery gets a new trial, it's over for him. Just thankfully that only one of them has died since this all, and he's the only one that's so far gotten off scot-free. When this all comes to light, Mr. Dennis Jacobs. But like I said, there's document 207, which is, well, let's see. I don't know. I might read it. I haven't read it yet. I just know it's 49 pages. It's got a whole bunch of exhibits listed. I didn't even look at the price for it. I know it was bundled up into like, I think 6 different documents, but it's all came in one. But yeah. Y'all have a good day. Until next time. Keep it classy. And happy birthday, Teresa Halbach. May you rest in peace.